Welcome to the Cyber Risk Management Podcast. Our mission is to help executives become better cyber risk managers. We are your hosts. I'm Kip Boyle, CEO of Cyber Risk Opportunities.
And I'm Jake Bernstein, Cybersecurity Counsel at the law firm of Newman DuWors.
And this is the show where we help you become a better cyber risk manager.
The show is sponsored by Cyber Risk Opportunities and Newman DuWors LLP. If you have questions about your cybersecurity related legal responsibilities,
and if you want to manage your cyber risks just as thoughtfully as you manage risks in other areas of your business, such as sales, accounts receivable, and order fulfillment, then you should become a member of our Cyber Risk Managed program, which you can do for a fraction of the cost of hiring a single cybersecurity expert. You can find out more by visiting us at cyberriskopportunities.com and newmanlaw.com.
So, Kip, what are we going to talk about today?
Today, Jake, we're going to talk about one of your favorite subjects, attorney-client privilege for better cyber risk management.
Sounds good. Let's go ahead and start.
Okay. Right. So I've heard of attorney-client privilege in movies and television shows, but what is it really, and why does it matter for our work?
Sure. So, yeah. The attorney-client privilege is the oldest privilege recognized by English and American law. A privilege in general is a evidentiary rule that says you don't have access to this, and it also it'll prevent you from testifying in court. You can claim privilege. So a really common one that most people have heard about is the your Fifth Amendment right to not self-incriminate. So that's considered a type of privilege. And what the attorney-client privilege does is specifically protect communications between attorney and client that are about legal advice. Now, it's not absolute. Nothing, for the most part, nothing in law really is absolute, but it is one of the most sacrosanct of the recognized privilege and least likely to be pierced by a court order or by a judge saying testify anyway.
And when you say pierced, is that what you mean by that? Is that little piece of jargon right there means like when you pierce the corporate veil?
It's very similar, yeah. So the idea would be, the privilege can be pierced, can be discarded, it can be set aside. I mean, the idea is that we're going to make a choice to ignore it. And there are very few exceptions, broadly speaking, to ACP, and they relate to general lawyer ethics overall. So, for example, if my client comes to me and says, "Jake, I'm going to kill someone in 6 hours," I have to report that. So that's actually a situation where there is no ACP, and I have to actually report that because it's a risk to. Of death or severe bodily harm. On the other hand, if that same client comes to me and says, "Jake, I killed someone yesterday," then there is attorney-client privilege, and I cannot breach that. Now we're talking about a criminal investigations and advice.
Okay, so a client after the commission of a crime can enjoy the ACP, so that. Again, I'm going back to the movies here, but that's so they can get the best possible legal representation?
Well, there's a number of reasons for it. One of the justifications is that without the attorney-client privilege, why would you tell your attorney anything? Like, if you know that you can, so what we really want to do ultimately is we want people to have the best possible defense. They cannot have the best possible defense if they can't be honest and truthful with their attorneys. And so the only way they can be honest and truthful with their attorneys is if they feel that whatever they tell their attorney stays with the attorney. And that's kind of the idea behind the attorney-client privilege.
Okay. All right. I want to go back to something you said a moment ago about like if somebody says, "I'm planning to commit murder in 6 hours," that's not going to be covered by attorney-client privilege because it's a risk to a person's life. Is there a similar obligation to inform if somebody says, "I'm going to blow up a big building, but nobody will be in it, and I'm going to do that in 6 hours"? That's like great property damage. Does that also invalidate ACP?
That's interesting. I think that the risk that life would be harmed is still pretty high in that. But That's a hypothetical that I have not considered in a while. Yep.
Sorry.
If I can guarantee that no one's going to be hurt, I don't know. I'd have to go back. I'd have to check.
Okay, well, I'm not planning to do anything like that. So I just thought it was interesting. All right.
Well, you know what? It's similar. That aspect is very similar to like the counselor patient privilege, right? If someone says I'm going to kill that person, you have to make a judgment call. Did they really mean it? Did they
Right.
not? Right? So
Yeah.
it can be confusing.
And
So
this goes back to my my education on the attorney's career simply by watching television and movies.
yeah, yeah,
Because I remember watching a Sopranos episode where Tony Soprano goes to see his counselor, and she explains confidentiality and exceptions to confidentiality, and so he starts being a little bit more careful about what he says to her, because some of the things that he wants to talk about are things that haven't happened yet.
yep. Nope, that's an issue. Totally.
Yeah.
Yep.
Okay, so that's attorney-client privilege, ACP. And I've also heard you talk about something else before, which I think was like attorney work product. Yeah, talk
Yeah.
about that.
So the attorney work product doctrine is not. It's not a privilege in the same sense that attorney-client privilege is a privilege, but
Mm,
it is part of the civil rules of procedure and the rules of evidence. And basically, what it says is, my notes, my mental impressions, things I create in anticipation or preparation for litigation are not discoverable.
mm,
So it's related and similar to attorney-client privilege, but it it really is. It adheres to the attorney's work product, hence the name attorney work product doctrine.
mm, mm,
Um, Other actual privileges with varying degrees of strength would include the spousal privilege. A judge cannot force a spouse to testify against another
mm,
or the other spouse. Um, there's the doctor-patient. There's a priest and confessor type privilege. Those are recognized, and a lot of these are, none of these are absolute, and a lot of them are recognized for a similar reason, right? It's a custom. It's a um, you know if we don't recognize that privilege, then people won't do X. So that's
mm,
kind of the idea here.
mm. Interesting, especially the spousal privilege, right? So I suppose that would be sort of like saying, well, for the good of the institution of marriage, if we didn't, honor that, then spouses, wouldn't tell each other what's going on.
Right, and so one of the things we haven't really talked about is with respect to privileges, who owns the privilege, which really means
Oh,
who can waive the privilege. So the attorney does not own the privilege. The attorney-client privilege is owned by the client. The client can waive attorney-client privilege. The lawyer cannot. Um,
okay.
in the spousal privilege context, both spouses own that privilege and both spouses can waive it. So guess what? It doesn't tend to come up in divorce proceedings, because in that situation, they're going to testify against each other all the time.
Right.
And so one spouse can't use that. You can't use it offensively, right? You can't say, no, she can't say that because spousal privilege. It's like, no.
Ah,
She waives her spousal privilege, she can say it. So
got
that's
it.
kind of and that's one of the reasons that we talk about the the client can ultimately waive privilege when it's time.
Okay. And this is our listeners might be thinking, where is this going? But we're building kind of a little foundation here to talk about why ACP and these other privileges can be useful in terms of managing cyber risk, right?
Yeah.
So let's move on in the conversation, and let's talk about ACP. What does that mean in practice? Let's talk a little bit more about that, and then of course we're going to talk about how this translates into specifically cyber risk management. So what else about the practice of ACP and AWP, right? The attorney work product?
Yep, attorney work product doctrine. So the way that this works in practice is that if your attorney is giving you advice, or you're asking questions of the attorney, and the attorney responds with legal advice, those communications are privileged, which means that neither the attorney nor you can be forced to divulge the substance of that communication. Interestingly enough, you aren't necessarily allowed to keep the fact of those communications secret. In the cyber world, we would call that metadata. The metadata of the communications is not secret. For
Right.
example,
So the metadata is like the day that, like, there was a call. Kip was on the line, Jake was on the line. It started at this time, it ended at this time.
right, or most commonly an email. Yeah, if I might be able to say that an email is, well, I can claim that an email is privileged, but if I do that, I have to put it on something called a privilege log in litigation. What that is a list of documents that I'm withholding, and then based on what privilege, usually the ACP and attorney work product. But what that has to, the privilege log has to describe documents enough that I can potentially contest the claim of privilege or work product. So, when I said that the privilege is not absolute, one of the main reasons it's not absolute is that in litigation, I can say, I don't buy it. That wasn't legal advice. This happens all the time with in-house corporate counsel, because in-house corporate counsel tends to give a lot of legal advice, but also a lot of business-based advice.
Oh, okay.
And business commentary is not privileged. So, that's what happens. And so what a privilege log looks like is your typical email metadata, to, from, CC line, possibly the subject, although you might be able to redact part of the subject if there is substance in there. And then of course time, date, stamps, and all that good stuff. So that's what it looks like in practice. And the same thing holds true of full documents. So, there might, if I give a client a memorandum, that memorandum is going to have so-called metadata as well. It's, when did I give it to them and what's the subject, and that kind of stuff would have to be listed in a privilege log.
Okay, how interesting. So I don't have any experience with this, and I could just imagine if somebody showed me a privilege log, I would want to try to pierce as much of that as possible, right? Because I know if it's on the log, then that means that it's relevant. And if I was the opposing counsel, I would want access to that. So I would imagine that there's quite a bit of thought and effort put into trying to figure out how to get as much of that off the log and into my hands as possible. Is that about right?
That is right, and that's one of the things that drives up the cost of litigation. The vast majority of the cost of a lawsuit is in the discovery phase, which includes litigating about, basically it's all about what information and what evidence can be exchanged, has to be exchanged, and all kinds of stuff. Like, the way that you would contest it is file a motion to compel, which means that you're asking the court to compel production of or disclosure of something. So
okay, so I'm going to sue you. I want as much information that you have to help me build my case against you, but you're going to have a log of things that you're going to claim are privileged, and that those records would not be available to the other party. Is that a good summary?
Well, let's just actually take through an example regarding cyber risk, because that's really what we're trying to do here. So
great.
So here's a quick hypothetical. In other words, a story in attorney speak. And this is what happens if you don't think of cybersecurity as, quote, legal advice. So let's say that I am Acme Company, and I need to, I recognize that, my cybersecurity and my cyber risk management isn't very good. So I have two choices. I have many choices, but in this hypothetical, I have two choices. I'm going to get a cyber risk assessment done. I can either go and find a provider, and I can just hire that provider, and I can do my cyber risk assessment and go from there. Or I can find an attorney who does cyber risk management, and I can ask the attorney to do a cyber risk assessment and go from there. So let's take the option one. Let's say that you get your you get your assessment performed by a cyber risk non-attorney provider, and you are, what's going to happen in a cyber risk assessment, right? They're going to tell you what your risks are. They're going to tell you what you should, how and when and what you should do to mitigate those risks. So they're going to give you a menu of options, and that menu is likely to cost money. And ultimately, you're going to have to do a number of things. You're going to have to act on it. You're going to have to purchase things or spend resources, and basically just make a normal, set of business choices.
Yeah, and you may choose to accept some of those risks.
And you may choose to accept some of those risks. And really, this is this is very a normal process. But here's the problem. Let's say that you're informed of 10 significant risks or potential vulnerabilities, and you're like, okay, we can only fix 5 of them right now. And 6 months later, item number 6 happens to be the root cause of a cybersecurity incident or breach.
Right, but you've accepted it for the time being.
Well, you accepted it, or essentially you've accepted it because you didn't fix it when you could.
Right.
But it might have been on the roadmap. You just didn't get to it yet.
Right. Okay.
And if there's a lawsuit or an investigation, then what's going to happen is either the government, whether that's the FTC or Europe, moving forward with GDPR, or a private lawyer is going to say, basically give us all your documents related to your cyber risk management. They're probably going to ask a specific set of questions like, did you get a cyber risk assessment? Now, this is one where if you answer no, you kind of lose right away because that's unreasonable per se. If you answer yes, then they'll say, great, who did you use for your cyber risk assessment? And you're going to have to tell them, well, I use this vendor. And they're going to say, awesome. We want all communications with that vendor. We want everything that vendor gave to you. We want all deliverables from that vendor. And so they basically get to look behind the curtain and see everything that you saw. And that's going to give them a big leg up when they argue in court that you were not reasonable in your cybersecurity.
Okay, and they'll probably see that 6th risk was unaddressed at the time that bad thing happened.
They will absolutely say they will notice that, and they will make that their case. And what's going to happen is you will spend a lot of time and energy litigating whether or not that was reasonable. And they're going to have a big advantage showing that maybe you weren't reasonable. So,
okay, so that's option 1.
That's option 1. Let's look at option 2. So if you instead hire a lawyer, and let's just say that the lawyer's like, yeah, I do cyber risk and I'm very knowledgeable in this, and I can give you legal advice, but I'm going to hire the same vendor because I want to have someone come in and assist me with that. This is pretty standard. It's not any different than a personal injury lawyer who hires a private investigator to follow the plaintiff around to catch them playing tennis after they've claimed that they can't move, right?
Okay.
You see that all the time in TV shows, but it's real. I mean, that kind of stuff is real. And so when the lawyer is supervising this process, there's a number of things that are happening. One, there's a attorney work product being made all the time, right? Why are you doing cyber risk assessment? Well, really, it's in anticipation of litigation. Ultimately, I mean that's not the only reason. You want to do good cyber risk management. You want to prevent it, but it is one of the things you're protecting against is a lawsuit, and one of the issues in all cyber risk management is whether or not you're reasonable, which is a legal question based on legal precedent. So,
and we're seeing this all the time these days, right? With Equifax and Uber and Target and Home Depot, right? These very, very high-profile data breaches. They were flooded with lawsuits against them.
Oh yes, it's constant stream of lawsuits. So let's move ahead to the same. We'll use the same background, same issue arises, number 6 on the list. This time though, when the person asks you, did you do a cyber risk assessment? You're still going to say yes, right? But then the next question is going to be, okay, well, who did you do it with? And you're going to say, our attorney handled that, and the remaining information is privileged under the attorney-client privilege. And then they can ask the same set of questions they were going to ask, and every time they do, you claim privilege. And that means that now, instead of just getting all of that documentation and evidence and information, Now, if they want that, they have to go to court separately just to argue about the attorney-client privilege and whether or not it applies, right? It's a massive, massive barrier. Like I said, it's not absolute, right? I mean, even a concrete wall can be knocked down with enough effort,
Right.
but it is very, very strong.
So this is really interesting because in my experience, if I was an executive and I wanted to get a cyber risk assessment, thinking back, I would probably not think that a lawyer should be the first person that I would go to, right? I would think about, well, I should find somebody who's a technological expert because these cyber risks have all to do about technology, right? So why would they? I mean, that seems like the place to go. Why would they go to an attorney first? And that's really what we're talking about here. And so I think another point you're trying to make is that cyber risk isn't so much a technological issue as it's now a legal issue. Am
It
I getting
is.
that?
You are. And look, this is actually not any different than environmental law 30, 40 years ago, right?
Mm,
You know, at some point, if if you're an executive of a company and your assistant walks in and says, "Sir, uh, one of our trucks just spilled a ton of coal all over, a park,"
mm-hmm.
right? Originally you're probably going to say, "Well, that's unfortunate. Why don't you call the cleanup guys?"
Right.
Right? However, once laws were passed about environmental regulation and environmental damages, and once those laws were enforced by, for example, the EPA, instead of saying, great, call the cleanup guy, you are immediately on the phone to your lawyer because now you need to protect yourself. So
Mm,
that is where we're going with cyber risk. It's early, but I think more and more clients are wising up to the fact that this can be protected by an attorney, and it should be, because let's be clear, what was the reason that we talked about for why you want attorney-client privilege in the first place? The reason is so that you can be honest and open about something that is sensitive, right? So imagine doing a cyber risk assessment without an attorney.
mm-hmm.
You basically have to just take the customer's word that what they're telling you is correct. A customer, though, is never completely unknowledgeable about these things. They may just not tell you something if they feel that if they know that it's a bad thing. Like, for example, there are 5 email servers in my basement that are used but that are not part of the corporate network.
Mm-hmm.
That is per se a bad thing, right? If a lawyer, however, is involved in the process, with the protection in place, the client is now able to more confidently disclose that sensitive
Mm-hmm.
information. You kind of so
Yeah.
so there's actually multiple levels to why you'd want to do this.
Okay.
It's not just the legal protection. It's also getting full disclosure from the customer, so
Right.
that they feel
So
comfortable doing that.
right, so that they can share more freely without having to have some kind of a nagging voice inside their head saying, "Oh, I don't think I should have said that."
Exactly. And you see this all the time, with currently sexual harassment investigations, things like that. I mean, you're not going to call HR when you learn about that. You're probably going to call your lawyer, then call HR.
Mm-hmm.
And that's because you know that there's a lot of legal liability associated with these types of issues. And so that's really what we're talking about. It's the same thing, and that's why we do it this way.
Okay, so just to sum up, if you're an executive and you want to get a cyber risk assessment, or you're asking yourself, should I get a cyber risk assessment? And if it occurs to you that, like, gosh, I don't want all that stuff written down, that could come back to haunt me, so I'll just not do the cyber risk assessment, and and then if something blows up, I can just kind of say, oh, I had no idea. But
Well,
what you're saying is like, no, that's actually not going to work.
Well, so I've actually heard people say, I don't want to know. I'd rather not know.
Mm-hmm.
And the problem with that is that I call that the head in sand defense. And it's actually not a defense. If your head's in the sand, then you're not going to even see me walk up and, kick you on the butt and push you over, which is exactly what happened in a legal sense. Because if you say, I didn't even do a cyber risk assessment because I just didn't want to know, that's indefensible, right? How can you ever take reasonable cybersecurity measures if you don't even know what your cybersecurity risks
Right.
are?
So one of the risks legally there is not only would you potentially be found guilty of whatever happened, but would that also open you up to a charge of negligence?
Well, absolutely. I mean, and negligence is kind of one of the standards involved here. Negligence just means that you had a duty and you breached it. So that is, that's a component of your failure to be reasonable.
Right. Oh, this is fascinating. So you can hire an attorney to help you with your cyber risk assessment, not just because the attorney is a cyber risk expert, but because that attorney can go and can bring other experts into the situation. And so you can get as many experts as you want on whatever aspect of cyber risk you want. And all of those conversations and all of those reports are all protected by attorney-client privilege. Is that pretty much the sum of it?
It's pretty much true. There's going to be some rules that have to be followed, but by and large, yes, that is the case. If you're following the rules and keeping the attorney involved and being careful with the privilege, then yeah, that is the idea. That's how it works.
Oh, that sounds like a very good option for executives these days. The way things are going. Any last thoughts about attorney-client privilege?
I would never recommend. I personally don't think that there's any reason not to do cyber risk work without attorney-client privilege. Perhaps I'm biased in that statement.
You might be.
But I think maybe self-interested. But I do think that it's a really, really important point, and that as these lawsuits and investigations become more common, particularly as GDPR moves forward, we're talking. It's March 27th. There are now less than 2 months until GDPR enforcement begins on May 25th, 2018. That's going to be a whole new ball game. And you really want to make sure that your cyber risk is not only managed, but managed under attorney-client privilege.
Right. Okay. Well, thanks for everyone for joining us today on the Cyber Risk Management Podcast. And today we talked about attorney-client privilege and how that can help you have a higher quality cyber risk management program. Thanks, everybody, for joining us today on the Cyber Risk Management Podcast.
Remember that cyber risk management is a team sport and needs to incorporate management, your legal department, HR, and IT for full effectiveness.
And management's goal should be to create an environment where practicing good cyber hygiene is supported and encouraged by every employee. So if you want to manage your cyber risks and ensure that your company enjoys the benefits of good cyber hygiene, then please contact us and consider becoming a member of our Cyber Risk Managed program.
You can find out more by visiting us at cyberriskopportunities.com and newmanlaw.com. Thanks for tuning in. See you next time.